Hi everyone. Today I wanted to talk to you about a question that I get time and time again from friends, family, clients, which is why do civil cases in India take so long? And why is that? Why is it that after you file a suit, it takes about at least maybe 2 to 3 years for the suit to get finally disposed of, or maybe even more, and we will get to that. So today I wanted to take some time out to talk to you about the different stages in a civil suit or in a civil case. So what happens from end to end? So let's say I file a case against you for recovery of money. So the first step is I issue a legal notice to you which precedes the actual filing of the suit. And when I file a case against you, I file something called a plaint, which is a short form for a complaint. And I file the plaint against you, where I say he Mr. X owes me so much money, and I put out all the facts there and so on. After that, there's a notice that is sent out to you or to the person who I filed a suit against, and that stage. So that is the second stage, and that is the stage of summons. So a summons has gone out, intimating you to come forward to come to court and to defend yourself in court. Now this happens for a month maybe, because a registered post has to go to the other side, assuming nobody responds, and sometimes there's something called a substituted service, which basically means that I'll say in court, look, nobody's coming forward. I'm going to put a public notice in the newspaper, and the newspaper is going to call people, so the hope is that you will look at the newspaper and see that there's a case that's filed against you. So that's summons. Now let's say that the notice actually reaches you. Now you want to come forward and you want to defend yourself. So you file something called the written statement, which is, in the US they call it the answer, which is basically where you come in, where you answer to my complaint, where you come and say, okay, look, Ramana is saying that I owe him money, but actually here are reasons why I don't owe him money. And sometimes you can even argue that actually Ramana owes me money, and here's a counterclaim that I'm filing against Ramana. And so you come and file your written statement, and this is usually done say within 30 days after receiving summons, or maybe extendable up to 90 days. Now once you file the written statement, and before I proceed, let me just clarify. There are two timelines in any civil suit. So one timeline is the main case, which is like the complaint, the summons, the written statement, and will go forward. The other timeline relates to, there are a lot of these miscellaneous applications that are filed throughout the suit. Think of these as housekeeping, in-house applications. So suppose I file a case against you to say that okay, that this is my property. So I may file an application in court to say, look, until the case is disposed, let him not sell the property. Let him not create other third-party rights and complicate the issue. So I will file an interim application to say that don't alienate the property till the disposal of the suit. And there are many such miscellaneous applications that are filed for various reasons, just so that what we are fighting for is actually protected till by the time the suit concludes. So those are so I want you to conceptually think of two timelines. One is the main suit, the other one is these interlocutory applications that also go on during the course of the suit. Now coming back to the main suit, so I file a complaint, there's a summons that goes out, you come back, you file your written statement. The fourth thing that happens is, I have the option to file a rejoinder to your written statement. So I can come back and file a rejoinder, but I can only do that with the permission of the court, because the court says once I filed a complaint, once there is an answer or a written statement, for any further pleadings to be included, you need to take permission of the court. So let's say I file a rejoinder, I get permission from the court. The next step is framing of issues. So issues are basically, these are questions that are framed by the court, because ultimately the court has to give judgment on something. And answers are only as good as the questions that are raised. So the court will look at the complaint, they will look at the written statement, they will look at any rejoinders, if any, and they will frame questions as to, okay, what are the questions that are to be decided in this suit? And they may, so in a recovery of money suit, it could be, does Mr. X owe Ramana money? Number one, did Mr. Y stand as a guarantor to X? Number two, were the goods that were delivered, were they defective? Which is why, which is a claim that is being raised in the written statement as to why money should not be paid, and so on and so forth. And they frame issues. Once issues are framed, then the next step is that I, the plaintiff, Ramana is filing the suit, I will call my witnesses, and they called a plaintiff witnesses. So for short form, they call PW, so plaintiff witness. So I call PW1 into the witness box. So PW1 comes into the witness box, and they file something called a chief affidavit. So they file an affidavit stating, giving their evidence as to their series of what happened. So my witness, most likely it's going to be something along the lines of what is in the plaint or in the complaint, because the evidence cannot go beyond what the complaint actually states. So the complaint will, or the evidence will have, as to what evidence I will be filing to support my case. Along with the evidence, I'll also be filing documents. So what happens is, let's say there are 1,000 documents. There could be 1,000,000 documents as to which I'm relying on. But I would have to limit my word and say, look, here are the 10 documents that I'm relying on. And this is important, because tomorrow you cannot rely on an 11th document. So you need to curtail your word to the 10 documents. You cannot subsequently you could say I did not mark a document because of XYZ reasons. But it's very difficult that once, if you don't mark your documents, to go back and then remark them again. So you mark your documents, and my witness comes and he says, okay, here's document number 1, document number 2, document number 3. After that, I open my witness, which is PW1, for cross-examination by the defense. So your lawyer will come and he will cross-examine my witness, and he will ask him, can you identify which invoices are paid, which ones are not paid? Can you say the goods were defective? And he'll put all kinds of questions to poke holes in my case. Now, I have a chance to call PW2 if I feel, PW1 was pretty ineffective, so I'm going to call PW2. So PW2 comes into the witness box, same thing happens, they come and cross-examine. And, once I feel that I've reasonably established my case, I will say, okay, I close my evidence. And then the defendants, that is, the person whom the case is filed against, they have a chance to come, and file a case, or to come and open their evidence. And so they are called DW1, or that is the defendant witness 1. And they file something called a chief affidavit again. They come and they mark their documents. Then I cross-examine DW1. And if I do a good job, then, they may think, okay, we may need DW2. So DW2 comes into the witness box. I cross-examine DW2. And, so on and so forth. And after the defense feels that, okay, I think we've reasonably established why we don't have to pay Ramana, they close their evidence. Then the matter goes for final arguments. Final arguments are heard by the judge, and who ultimately pronounces the judgment. So that is, the end-to-end of a civil suit. What I'm not going into now is, let's say that I win the case. And I say, okay, Mr. X has to pay me. So what I have in my hand is the judgment of the court that X has to pay me. Now, how do I execute this judgment? And that is a whole another ball game in and of itself. Because what good is a judgment if I'm not, if I can't do anything with it? I can't literally, that judgment, it's not like I can take the judgment, put it in a vending machine, and I'm going to get money out of there. So how do I execute the judgment? That is a separate topic for another day. So, all this, the entire procedure for the suit takes time. Summons have to go out, you need to come back and file your written statement, evidence has to come. I have to call my witnesses, their schedules have to kind of match with the schedules of the court. And, then the defense witnesses have to come, their schedules have to match with the schedule of the court. And then, cross-examinations have to happen, documents have to be marked, finally arguments have to happen. And in the meanwhile, there are these interlocutory applications that have to be filed, and so on. So these things take time. Clearly, we need amendments to shorten the process and try to make it more expeditious. But that's the process that we have today. I hope you learned something new, and thank you for watching.